Honorable President, honorable judges of this court, I'm grateful for this opportunity to present the second round of oral submissions on behalf of the Republic of India, responding to the points that were made yesterday by Pakistan. I start with some issues, sir, Mr. President and honorable judges, which should never detain this court and waste its precious time. But since they arise and have been raised and almost given center stage, I propose to deal with them briefly. Pakistan, through its council, made a scathing attack on India's memorial, and also did not spare the legal counsel who have assisted India in preparing the memorial. They overlooked that there is a fundamental difference between proceedings brought, for example, in a United Kingdom court under the rules of the court, and proceedings brought before this court. The proceedings in this court are applications filed by sovereign states. No private party generally has a right to bring proceedings in this court. Under Article 38 of the rules, an application before the court has to be signed by either the agent of the party submitting it or by the diplomatic representative of that party in the country in which the court has its seat, or by some other duly authorized person. The signature of a person other than the diplomatic representative has to be authenticated by either the diplomatic representative or by the competent authority of the applicant's foreign ministry. Under Article 40, all steps after proceedings have been instituted shall be taken by agents. Memorials are filed under Article 49. The original of every pleading shall be signed by the agent and filed in the registry. Consistent with the dignity of the sovereign states who file applications, there is no requirement for solemn affirmations of any kind as to the truth of the contents of the pleadings. Errors and misstatements in memorial are addressed by the other party in the counter memorials or in the rejoinders where permitted. The last pleading, the last word, even in oral submissions, always is with the respondent. A criticism of one sovereign state of the case made out by the other state must be in language consistent with the dignity of sovereign states and the majesty of this court and the solemnity of the proceedings in this court. Humpty Dumpty has no place in this court. This court has jurisdiction over sovereign states and conducts proceedings in which sovereign states are given directions which are binding upon them. This court therefore conducts itself with restraint and respect, which does not undermine the sovereignty of any of the states or shows disrespect towards any of them. The language which has echoed in this court, sir, in these hallowed precincts, is and so that such misadventures are not repeated. Perhaps this court may, in counsel's word, lay down some red lines of how proceedings ought to be conducted. The transcript is peppered with words such as shameless, nonsensical, laughable, breathtaking arrogance. On a quick count, shameless and nonsense occur 5 times each, arrogance 4 times, ridiculous 4 times, and disgraceful 4 times. And these are addressed to the submissions made in the memorial and the reply by the Sovereign Republic of India. India takes exception to being addressed in this fashion in an international court. Beyond saying this, I would let the matter rest, for I do not, and the Indian culture prevents me from indulging in similar language of invectives and insults. India believes we have a strong case, and so we have, sir, as the saying is, hammered the facts and hammered the law. As the old lawyer saying goes, when you're strong on the law, you hammer the law. If you're strong on the facts, you hammer the facts. And when you have neither on your side, you hammer the table. Bereft of a case, Pakistan has hammered the proverbial table. Since Council brought it up, I must mention that I have received a letter from him containing a veiled threat for my role in certain submissions and extracts of certain reports found in Indian Memorial's reply. This again is not a matter for this court. But since it was brought up, my only response is to say that there appears to be a fundamental misunderstanding as to the role of counsel in preparation of pleadings under the rules of the court, which were followed by India. No Indian pleading has been signed by any lawyer, unlike Pakistan's filings, and the rules of this court do not countenance filing by or through lawyers. Unlike the pleadings filed by Pakistan, India has filed pleading in its own name, signed by its agent, and takes full responsibility for the content of its pleadings. On 5th of June 2018, Pakistan wrote a letter to India demanding a confirmation that the contents of the reply are in all material respects accurate, and requesting India to confirm whether its lead counsel had reviewed or approved the reply as filed. India replied on 27 June asking Pakistan to raise any issue they desired before this court in accordance with the rules, and that, and I quote, the details of the preparation review process, including leading to the final submissions, is purely internal to the government of India. The queries raised by the government of Pakistan are therefore inappropriate and irrelevant, unquote. On 17th July 2018, the rejoinder was filed in which Pakistan pointed out the alleged mischaracterizations and misquotations. The matter should have ended there, leaving it to the court to hear submissions and deal with the expert report appropriately if necessary, since the original of the report was in any event on the record of the court. On 18th January 2019, India received from this court a letter attaching a communication of the same date received by the court from Pakistan. Paragraphs 6 and 7 of the letter raised the issue of the alleged mischaracterization and misquotation. It magnanimously offered the government of India an opportunity to consider its position, and with Pakistan's characteristic humility, which we saw on display yesterday, demanded a forthright apology and undertaking not to repeat these matters before the court. This letter raised various issues in relation to the cross-examination of Mr. J.P. Singh. A response was given to this letter on 23rd January 2019, in which, on these issues, India maintained its position. The matters arising out of these letters of 18th January 2019 and 23rd January 2019 were dealt by this court and its communication of 24th January 2019. The only order made was that the request for cross-examination of Mr. J.P. Singh was declined. Pakistan continues to raise this issue, and in my opening I pointed out the typographical error in paragraph 154D of the reply,